Good afternoon. Welcome to the Joint Veterans Endorsement Interview for Judicial Candidates. On the onset, we would like to formally recognize and thank our sponsoring organizations for making today's event possible. Veterans in Politics International, Nevada Veterans Association, Armed Forces Chamber. We also extend our sincere appreciation to the additional sponsors, community partners whose support ensures a professional, fair, and transparent endorsement process. We'd like to mention the following judges for their support. Judge Jacob Reynolds, District Court 29. We are honored to have you all. We're honored to have you here today. Before the interviews, we got to go over a few rules. It's just you, so we're just going to give you, in a nutshell, we're going to introduce ourselves. You're going to introduce yourself, what position you're running for, and why you're running for it, why we should endorse you. We'll ask you questions. You have 1 minute and 30 seconds to go over the question. You're by yourself, so give or take 10 seconds or so. And after that, then we'll continue on with the questions. And after that, we will conclude the interview. I can't say there's no debating because there's nobody here, so it's just you and us. In the interest of fairness and transparency, Veterans in Politics International and Nevada Veterans Association will be abstaining from the interview due to the fact that the VIPI Consulting LLC, whose president is Steve Sanson, represents one of the candidates here today. Armed Forces Chamber will be the sole organization conducting the interview. Okay.
Gary Jacobs, Armed Forces Chamber.
J.P. Edwards, Armed Forces Chamber.
I am Judge Mary Perry. I am Judge Mary Perry. I am the presiding judge in Department P in Family Court. And why I should have my job is I believe I am still the most qualified to be the judge in Department P. I have a passion for the children. The parents come in front of me, and I have a passion to protect them, to make sure that their lives flow as greatly and evenly and as good as I possibly can, because they have rights also that sometimes in a divorce or in custody battles, the parents forget.
Gary Jacobs again, Armed Forces Chamber. My first question for you would be, how would you handle a situation where a major campaign donor appears before you in court?
I take the attitude that I have no friends, I have no donors, I don't know anybody out there. You're coming before me, it's going to be the facts of the case, it's going to make a determination on how I rule. I have many people that I've known for 25 years come before me. A lot of them I completely respect, but when they come into my courtroom, I have no friends. I am a judge, and I will do my job.
Thank you. Are you going to ask?
Okay. Describe a time when you had to make a legally correct decision that was unpopular with clients, colleagues, or the public. How did you handle it?
I kind of have to make those decisions daily. When people come before me, they want what they want. Each party wants for me to make a decision on their side, and I can't do that. I have to follow the law. If it's custody, I've got 12 factors that I have to look at. If it's child support, they tell me how to make the determination. I have a little bit of judicial discretion and some leeway to give downward deviations on that, but I have to follow the law. And when it's a distasteful decision, I still make it, and then I go home and, and hope I did the right one. If there's no guidance in an area and I'm not sure which way to go, then which way does my instinct tell me I should go? What do the facts say? I write the decision, and if they don't like it, they can appeal it. If I'm reversed, which I get reversed a lot because I believe in getting guidance from the Supreme Court when there hasn't been any guidance.
Gary Jacobs, Armed Forces Chamber, once again. What are the statutory factors a judge must consider under NRS 125C in determining the best interest of a child?
There are 12 factors. You start off with what do the children want? Are they of sufficient age and capacity to even make that determination? Then has the parents, had they pointed out a guardian? Which one's going to allow the frequent association with the other parent? Do they cooperate to meet the needs of the children? Is there any conflict between the children? Is domestic violence? Has there been an abduction in the case? Has there been any abuse and neglect on the children? And what is the mental health and the physical health of the parents? What are the physical, mental, and educational needs of the children? And for the life of me, I can't think of the other two. Oh, you got an other, and I can't think of the other one off cuff.
Totally fine. Thank you.
See, if there was three of us here, we could have worked together on answering those.
What is the standard? What is the standard for granting? I'm sorry. What is the standard for granting a preliminary injunction under Nevada law, and how do you balance irreparable harm versus the likelihood of success?
More often than not, that is something that does not necessarily come in front of me. We already have a joint preliminary injunction that the family court recognizes, where it stops you from being able to relocate with the children with the intent to make their home in another state. You can't do anything to further encumber the community, sell property, or anything like that that's going to drain the assets of the company, and you can't go out there and get yourself deeper in debt. You can't do anything that's going to mess with the community without either permission from the other party or from the court.
Gary Jacobs, Armed Forces Chamber. This is not a question I have written down, but just looking at statistics, it says that approximately 80% of custodial parents in the United States are mothers, while only 20% are fathers. Could you maybe explain why a little bit?
I cannot necessarily explain that. I do know that when it comes to cases that come before me, the statute requires me to start at joint physical custody, and they have to have a darn good reason to go off of it. I am a firm believer that the children need both parents in their life for them to be well-rounded children. You've got situations where you've got maybe some mental health problems. You've got domestic violence that may have gotten, more than just one incident 10 years ago. You've got, maybe one of the parents have tried to abduct the children. These are things that you have to really take into consideration. The domestic violence is a rebuttable presumption. Yeah, there may have been domestic violence, but maybe then you got the other parent who decided to grab the child and just take off and leave with the child. That's abduction. So now you've got two of these situations where neither one of them should really have primary, so we give them joint.
How do you handle, J.P. Edwards, Armed Forces Chamber, how do you handle self-represented litigants while maintaining neutrality, avoiding the appearance of advocacy?
I just treat them equally. They come in front of me. I know that they do not know what they're doing. They're scared to death. They're about to lose everything that they worked for in their own mind. They're about to lose their kids and, get every other weekend. And I try to help them relax a little bit. I may joke around a little bit to get them to realize, hey, you know what? I'm not the enemy here. Let's see what's going to be best for y'all. I treat them fairly equally, and I start, I explain. I've got 12 factors to look at. And nowhere in those 12 factors does it say I consider sex of the parent. And nowhere do I consider who is it that did all the hard work to keep the assets. So, it's a community, and I try to treat even their divorce action as a community so that both of them walk out of there knowing they were treated equally and fairly.
This will kind of probably penny off of that. Gary Jacobs again with Armed Forces Chamber. How do you ensure your rulings are grounded in statute and precedent rather than personal philosophy?
I sit there and prior to me taking the bench, I took pretty much every one of the family law bills, and I wrote out, like for custody, you've got the 12 factors. I have that written out where I go through each one of those factors and decide exactly what it is. When I go to making a decision, after I've written it out, I read it. Is this fair? Or is this something that I probably, overreacted because maybe I didn't really like one of the parties? Do I need to, pull it back some and make sure that I am based more on the evidence than on any personal bias? And I recognize my own personal biases. If I have one, then I consider that while I'm listening, and I make sure that I try not to put anything that would have my bias in it in my notes for me to make my decisions from.
What are the statutes? J.P. Edwards, Armed Forces Chamber. What are the statutory factors a judge must consider under NRS 125C in determining the best interest of a child?
I just named them all, the 12 of them prior to, and I still can't remember the couple that I left out. To me, one of them is the cooperation. That to me, that's big. Are they cooperating to meet the needs of the children? That's the big one. And the frequent associations. Treat each other equally, and I'm going to treat you good.
Okay, so based on that, I'll ask you this. When J.P. Edwards, Armed Forces Chamber, what is your understanding of Nevada's open meeting and transparency principles as they intersect with courtroom proceedings?
Well, that also has something to do with the Constitution. People need to know how the courts are conducting themselves in there. There's a lot of privacy issues that may want to be called out when you're doing family law cases. But for the most part, the public has a right to be there. If someone comes to my courtroom and it's not a sealed case, because there's certain types of cases that we automatically seal, then they're more than welcome to come and sit in and listen to them. If there's going to be some facts that comes out, let's say a child is being sexually abused by someone, I'm going to seal that portion. I'm not going to let people come in here, because parents of friends of these kids should not be coming in here and seeing that this stuff is happening, and then all of a sudden their friends are hearing about it and it's getting spread all over school. So there are certain things that I will seal without any questions about it, but other things, it's open. It's supposed to be open to the public, and it needs to be open to the public.
Gary Jacobs, Armed Forces Chamber. How would you respond if a high-profile defendant publicly criticized your courtroom conduct during trial?
Depends on what the circumstances are and what they're trying to say that it is. If they're, am I conducting it with bias, or my demeanor? I will check myself and make sure that I'm like, okay, does that person have a point? Do they not have a point? Or are they just upset because they think they're losing the case? And I can't respond publicly because I can't talk about any of the cases that's before me. So if he takes the proper steps and files an affidavit to disqualify me, then, sit back and we'll let the chief judge make the determination if I need to be disqualified.
J.P. Edwards, Armed Forces Chamber. How do you interpret your role in managing courtroom efficiency without sacrificing litigants' due process rights?
I try to make sure that the litigants understand that the time for them to be able to go into deep detail and provide me with all sorts of evidence is the evidentiary hearing. That sometimes giving too much information at the beginning of the case makes it really hard for other litigants to get into the courtroom. Let's try, before you start smearing each other or, trying to say, well, I need to tell my story. Let's see if you can get along well enough to settle your own case. Let's send you to mediation because it's your child. Do you really want someone in a black robe telling you what you're going to do in raising your kid? Do you want to take more of a action yourself and say, you know what, this is what's going to be best for my kids. Because if parents agree, it's none of my business. And I keep reminding them, look, you get all day if you want all day with me. If you want to take it to trial, I will be more than happy to set one. And we will go to trial, and you can sit there and you can tell me everything you want me to know. You can provide me every bit of evidence. But for most cases, when it comes to a motion hearing or a status check, those are about 15-minute time slots for the people. And there's not a lot of stuff that you can get in there without taking away time from other litigants that wants their same time.
This is kind of just going off of what you were saying of how you have a 15-minute time window. Is there, if there is anything, would you do to possibly change the time frame that these families do get within the courtroom?
If I know that it's going to be a high volatility and they need to have a little bit more time, I try to give them an hour and put them in their own slot. I've got 40,000 cases assigned to me with 500, up to towards 500 that could be active at any given time. It fluctuates between 420s and up to the 490s based upon how many people are filing complaints. There's just not enough hours in the day to give everybody the time that they want on that first court appearance. And I would love to be able to do it, but there's just not enough time, or there's not enough judges. It's just not enough people. The resources are not there.
JP Edwards, Armed Forces Chamber. So I'm going to kind of word this a little bit different, being how this is family court. Describe your approach to maintaining decorum when, I say, litigants engage in repeated speaking objections or grandstanding.
I attempt to calm them down. I attempt to say, hold it, let's not inflame each other right now. This is not the forum. It's not the WWE. We need to keep it calm so that we can come to the proper decision on what to do in your case. Sometimes you got parents who, if you let them, they'll go at each other. And they want to argue back and forth with each other. And I'm like, no. You're talking to me, not to each other. You have to talk to me. What do you want me to know without showing your bad side? You don't want me to think bad about you, do you? Show me your good side.
Gary Jacobs, Armed Forces Chamber. Tell us about a legal position you once strongly held that changed after further study or experience. What caused the shift?
That one's a rough one. I think that even when I was practicing law, my decisions have always been based in the law. I try not to take a personal attitude towards it because it's the law. I'm not allowed to have a personal opinion on these things, and one of the big things is, with me being a veteran, I hate the fact that the VA disability goes into spousal support and stuff like that, And when I first came in as a law clerk, not quite understanding the full extent of what the law was in that area, I thought it was unfair. But once I sat back and started, researching it, learning it, understanding the whys there, then it's like, oh, okay, now I get it. The spouse has been there. The spouse has stood beside the vet, throughout a lot of it. So you need to consider that too. So it's just educating myself in what the law is what helped me change.
JP Edwards, Armed Forces Chamber. If you discover post-election that a campaign volunteer made a statement inconsistent with judicial ethics, what steps would you take?
I would have to report it to the Judicial Disciplinary Commission. I am required by the canons to self-report and let them know that I did not know that this happened, And, the campaign person did it and hope that they'll, take some sympathy on me.
Gary,
This will be the last question.
okay. Gary Jacobs, Armed Force Chamber. You being a woman and being in the divorce courts and kids, right? Dealing with kids, parental visits, rights, etc. You being a woman and a couple going through a divorce that's involving kids, and based off the statistics I have read, how 80% of guardianship goes to mother. How in your courtroom can you ensure that a father can feel that he's getting a fair chance?
When they walk into the courtroom, I ask them, do you have anything besides what you have? I look at their complaints. There's boxes, if they're an improper person, there's boxes that they get to check for me to consider. And if there's nothing that's been checked, because those boxes will include CPS, state of residency, domestic violence, and there's a couple of other things that, really, I think one of them is medical reasons and stuff like that. If there's nothing checked there, I'm like, then why should I give you sole legal, sole physical custody of the children? What makes you think you're a better parent? And they're like, I'm the mother. And I'm like, that's not good enough. Everyone's got a mother, everyone's got a father. It took two of you to make this baby. Y'all have cooperated to this point with the child. Therefore, we have to, start from there. And there's no reason for me not to do a joint physical custody setup. And I always start with joint physical.
Thank you. At this time, candidate, we're going to give you 1 minute to again reiterate what position you're going for and why should we endorse you.
I am Judge Mary Perry. I am the sitting judge in Department P, Family Court. I am asking for your endorsement because I believe that I am the most qualified for the job. I am the only veteran that is on district court, and I've been in the trenches. I know what it's like. I know just about every job out there, and I take all of that into consideration. And of course, Department P for Perry.
Thank you. That concludes our joint endorsement interview. Again, we'd like to recognize our sponsoring organizations, Veterans and Politics International, Nevada Veterans Association, Armed Forces Chamber, and we'd also like to acknowledge Judge Jacob Reynolds, Department 29. Thank you very much.
Thank you.